You're filming people.
I'm not filming. I'm not filming them people at all.
I've just stood watching you.
No, I was changing the battery.
Right. Okay. Well, I'm not going to dispute that, but you were stood by a fence line observing people. Have you got a ticket for the match?
For your own sake, in future, if you have press as well, because it's quite a common question for press that we would ask that
you're just using every trick in the book. You want to do this, don't you? Go on, come on, go and do it.
Your name and address.
Go on, do it. Come on.
I don't want to search you. I'm asking for your name and address.
Why do you want my name and address?
Like I've said.
Under what provision do you want my address? Just make it clear to me.
Based on the current counter-terrorism threat.
Yep.
You've been with this group of people all day. You're now on private property.
Yep.
You've disputed the fact that you're filming on private property. It's a massive, massive football fixture. 54,000 people are going to be present. You've not got a ticket.
A camera,
you're on private land.
A camera isn't a device of terrorist purposes.
And you're acting suspiciously.
I'm not. You're just using every trick in the book. You know what you're doing. I know what you're doing. It's cool.
I'm not going any further. I'll give you my grounds.
Straight away, we see a familiar problem with stop and account. The officer approaches the auditor simply for observing people near a fence. While police are allowed to ask questions, the auditor is under no legal obligation to answer unless has been lawfully detained or arrested under specific powers. The officer immediately jumps to counter-terrorism to demand a name and address, which is a huge escalation. Under Section 43 of the Terrorism Act 2000, an officer must have reasonable suspicion that the person is a terrorist. Standing in a publicly accessible car park or roadside and filming does not meet that threshold. The officer also raises private property, but trespass in the UK is a civil matter, not a criminal one, unless it becomes aggravated. At this point, police are inserting themselves into a civil issue without lawful authority to demand personal details.
So what provision are you enforcing, sir? Just to make it clear. No, what provision?
Like I've explained.
What provision? What section of what?
Under the counter-terrorism law.
Which section?
I'm obliged to ask for your name and address.
Yeah, but which section?
Which section?
Yeah, I need to know for my personal records, because I keep personal records.
That's fine. I'll refer to my pocket notebook and I'll give you a full legislation hit. But whilst we're doing that, you give me your name and address.
But you've got access to PNLD. If you can find a section, find a section, I'll comply with you.
That's fine. Good man. Have you got permission off the club to be here? No.
I haven't been asked by the landowner to leave. But
not at the moment you haven't, but obviously this is a football fixture and we're on behalf of the club.
You want to do the thing, I'll comply with you. I'm going in a minute anyway, dude.
You're going nowhere at the moment. Okay, you're detained until I
detained?
confirm your name and address.
Under what section am I detained?
I'm going to confirm that shortly, okay?
Shortly, because...
under the counter-terrorism legislation, you've been acting suspiciously all day around a large group of people.
You know I haven't.
This is genuinely hard to watch. The auditor asks a very basic but crucial question. What specific power are you using? The officer can't answer, and has to pull out his phone to check the police national legal database. If an officer deprives someone of their liberty, which he admits by saying the man is detained, he must already know the power he's using. You cannot detain someone first and then look up the law afterward. From this moment, the detention arguably becomes unlawful. Under Pace Code A, officers must clearly state both the legal power and the grounds before beginning a search.
No, because you don't like me being here.
I've got body-worn footage of you all day
have I.
in the city centre.
So have I.
Which concerns me slightly.
Why does it concern?
Because I'm lawfully obliged to take my video capture. You've said you press, you've got no press badge.
What do you want, my name and address, yeah?
You're lovely, yeah. Driving licence, any ID.
Just to...
And can you confirm which press agency you're working for, or you freelance?
Just to... which section am I providing these to you?
I will give you the section, like I've said. At the minute,
I'm detained without a section, I'm just detained?
Yes, you are, yeah.
Are you sure?
Yes, I am sure.
What's your calling number for me?
There's my calling number.
18241. Cheers, bro. There you go.
Much. I appreciate that.
No worries.
In 20 years of policing, mate.
You've messed up, not me, mate. You know this, and your colleague knows as well.
I disagree entirely.
No, your colleague knows as well, so he's laughing.
I disagree entirely, mate.
I know, dude. I know. Don't worry about it.
That's fine.
We all make mistakes, my friend. It's section 43, I think.
Well, it's very kind of you to try and reference that. Once I've put...
The officer now starts fishing for identification. In the UK, there is no legal requirement to carry or provide ID when asked by police, unless you're driving or being dealt with for a specific offense. The officer references suspicious behavior around a large group of people, similar to Section 50 of the Police Reform Act, but acting suspiciously is not a crime. Police must suspect a specific offense. Here, the Terrorism Act is being used as a catch-all tool to false identification, which is a misuse of power commonly referred to as phishing.
Yeah.
Are you registered at this address? Because it's an offence not to have the correct address on your driving licence. Are you registered at that address?
It's an offence to drive with it, but
It's an offence to have the wrong address on your driving licence.
what do you mean registered at the address?
Basically,
Do you live at that address?
Yeah, sometimes. You know, mate, you know.
I'm not going to take on any further, but you know what you're doing.
I know, I do.
What I will confirm with Manchester City is they're going to get your photo on their club cameras as well.
I don't
before we
care.
finish.
I don't follow football. It's for these kind of people. I don't follow football. Don't follow football. Not remotely interested, honestly. Do your worst. Tell the SAS.
It's frozen, so you have to bear with me for the moment, okay?
So am I detained under section?
The officer suggests that because the auditor doesn't have a formal press pass, he isn't press. That is legally incorrect. The UK does not license journalists. Anyone can be a freelance photographer or a citizen journalist. Credit where it's due. The officer remains relatively calm despite the auditor's sarcasm. However, the officer taking photographs of the auditor on a mobile phone is questionable. While police can gather intelligence, photographing a detainee who is not under arrest raises privacy concerns, even though officers often justify it for intelligence or reporting purposes.
At the moment.
You've referenced that. I've not given you my full grounds, but what I have told you is I've got enough grounds currently, based on your actions today and the evidence on my body-worn video, to suggest you're up to no good.
To suggest I'm up to no good?
If you've provided the fact that you're filming for a company and you've got permission
I'm not filming for a
here,
company.
You said you're a member of the press.
I'm freelance press. Anyone can be press. You can be press.
Yes, if you have a badge and ID.
No. You can consider yourself press. You can take photos. You're freelance.
I've spoken to many freelance press officers before, and they all have ID.
We're not required to carry identification in the UK. We are not required to carry any ID in the UK, whether we are a banker, a press photographer, or a footballer. You don't need to carry any ID. I promise you, sir.
I'm still frozen.
No worries.
So we're still here. Okay.
Still detained indefinitely.
Well,
with no section.
Details.
You can write it down. No problem.
When the officer says he'll be submitting intelligence, it exposes the real motive behind this stop: data collection. He likely knows he won't find anything dangerous. He just wants a name for the database. Section 43 powers cannot lawfully be used solely for intelligence gathering. If there is no genuine suspicion of terrorism, the search is unlawful. And if the officer truly believed this man was a terrorist, why is he allowing him to stand there holding a device without controlling his hands? The officer's body language completely contradicts the seriousness of the legislation he's quoting.
Here we go, we're on. System's working.
So,
what we'll do also, I'm going to fill in an intelligence submission when I go back to the station, okay? Detailing this stop and why we've done it, okay?
as you're required to do.
Yes.
The officer brings up the Manchester bombing, which is deeply tragic, but this is an emotional argument, not a legal one. Past attacks do not allow police to suspend civil liberties or bypass the law. The auditor correctly points out that while the area may be private land, it is open to the public. If the landowner hasn't asked him to leave, he isn't even trespassing yet. At this stage, police are acting more like private security, enforcing policy rather than law. The officer's comment about the auditor being disrespectful is irrelevant. Being disrespectful to police is not a criminal offense.
Again, it's really...
Nothing to do with you. Nothing. I get it.
If that's how you feel, mate, that's how you feel.
No worries.
It's okay.
You know I'm not a terrorist. I know I'm not a terrorist. She knows I'm not a terrorist. He knows I'm not a terrorist because he's seen me all day filming football fans, and he knows I'm press.
I know you're not up to no good, mate.
You know I'm up to no good. You know for a fact.
Yeah, you're trying to mouth off and one about the Manchester bomb and be disrespectful to what I do.
What? What am I
you,
doing that's up to no good?
You're filming in a private area, large groups of public entering an iconic site.
You're allowed to access this until you're asked to leave.
Right.
Trespass is a civil matter. It's not illegal.
Yeah. You're trying to question every ground I've
Of course I am, because I have civil rights, and the second I give them up, I'll lose them. You're the one being unlawful here, not me.
There's an important point here about assault and detention. The officer asks, "Have I laid a finger on you?" implying that no assault has occurred. But under UK common law, unlawful detention or false imprisonment does not require physical contact. If an officer tells you that you are not free to leave without lawful authority, that is a deprivation of liberty. If this were tested in court, the key question would be whether a reasonable person would suspect someone with a camera of being a terrorist. The answer is almost certainly no.
Because you haven't quoted the section or the provision.
This is a stop and account.
Yeah.
Have I laid a finger on you?
You've detained me.
Have I laid a finger on you?
That is an assault because you've detained me unlawfully. You know it's an assault. You don't have to touch someone for an assault. You know that. You're a cop. You know that. This is an unlawful stop search. £500 per hour, sir. You know.
That's an opinion from yourself.
No, it's fact, case law. I've done it a few times.
Very well.
Don't worry, it's going on. Don't worry.
You'll notice that's not speeding up my process. I'm doing my job now, okay?
Don't worry, dude. If it goes over an hour, it'll be... It's easy. You know what unlawful detention looks like. You know what it looks like.
Mate, I understand my powers, I understand my grounds, okay?
You haven't given reasonable grounds for a terrorist search. Well, you haven't given any grounds.
I've told you what
you just said suspicious activity.
At this point, the dynamic changes. The auditor discloses that he is a vulnerable adult with mental health issues. To be fair, the officer's tone immediately softens, and he mentions a duty of care. However, this also highlights a concern. Officers sometimes rely on Section 136 of the Mental Health Act as a fallback when criminal grounds fall apart. Here, it feels less like genuine concern and more like the officer searching for a way to end the encounter without admitting the stop was unjustified.
I was just literally changing the battery and going home until you unlawfully detained me here.
That's your opinion?
I know it is.
Okay.
We're not going to get into that.
To go home with.
I'm perfectly able to go home. I promise you. Promise you that.
Right, thanks very much. I'm going to ask you to leave the area now, okay?
Sorry?
I'm going to ask you to leave the area to the gate, and then that's public land.
I'm going home anyway. That was my plan. Just as I was changing the battery, I was going home.
If you'd have said that as we'd have spoken to you, perhaps things would have been differently.
I did.
Okay.
See you in a bit.
Have a good night.
You too.
The encounter ends with the officer asking the auditor to leave the area. Notice something important. No search ever actually takes place. The man was detained under Section 43 stop and search, yet he was never searched. This confirms the detention was about obtaining ID and moving him on. Overall, this was a clear failure of procedure. The officer detained a citizen without clear grounds, didn't fully understand the legislation, failed to conduct the search he claimed to be detaining for, and ultimately used counter-terrorism powers to resolve what was essentially a civil trespass issue. This is exactly the type of policing that auditing channels exist to expose.